still de novo. It's de novo for a different reason. And then, of course, the sufficiency question, if force and fear are alternative means, then the question of whether or not there was sufficient evidence on one of those means is a sufficiency analysis under Timley. So moving to the issue of whether force or fear are alternative means of committing the crime of rape, I start first with this court's precedent, which is Timley. And in Timley, almost 20 years ago, this court held that force and fear are alternative means. And that holding has remained solid law of this state until at least arguably 2010 when Wright was decided. And although it's my position that Wright did not hold otherwise. The issue of whether force or fear are in fact alternative means was never presented to or decided by this court in Wright. Various panels of the Court of Appeals have read Wright in that fashion, and they view Wright as a departure from Timley. And the panel here, and just as in Brooks, I believe...
Could you repeat that? I just didn't hear you. You said
I'm sorry.
The Court of Appeals have held otherwise and say Wright departed from Timley? Is that what you
said? They read
said?
Wright as a departure from Timley, yes.
On force or fear? On
force or fear as alternative means. I believe in Brooks, the panel in that case went so far as to say that the holding in Timley was really just dicta, and at the same time finds language in Wright that says that they conclude is persuasive, controlling authority. So that's the tension here is between Wright and Timley as the longstanding rule of law. And I would argue that the Court of Appeals is reading too much into Wright. As I said, the court did not indicate any intention in that case to overrule Timley. It didn't address the necessary tension between Timley and its decision in that case. And that's just because there was no issue before the court in Wright. The parties proceeded as if force or fear were a single means, and it was never questioned. And I would also note that if the court was intending to depart from that long-standing rule in Timley, it certainly would have said so in the decision. I mean, you can just count on that.
Assuming it wasn't before the court in Wright, what about Brown?
What about Brown? Brown did establish a clear analytical framework for dealing with this. So the question is, is Timley on the table then? Do we use Brown to reanalyze Timley? Precedent, as I understand it, remains good law unless the court can find some reason for overruling it, and that requires there are various factors, but among those are it was not well reasoned, it's no longer valid statement of the law. So applying the Brown analysis, I'm not conceding that point, but I'll proceed to argue that if you apply Brown's analysis to force or fear, you still end up with the same result as in Timley, that they are alternative means. And the first part of the Brown analysis is that we look to legislative intent. Did the legislature intend to create alternative means? And the court has said that we first look at the structure of the statute. That's often very telling. If the legislature has broken out different means of committing a crime into separate subsections, it's a pretty good indication of their intent, that they intended these to be alternative means. And I submit that force or fear are not in separate subsections. However, that's not controlling. In this court's decision in Haberline, the court held that taking or confining in the kidnapping statute were alternative means, but they are not set out in separate subsections. Just like the force or fear, they are in one section of that statute. And so that doesn't resolve the issue in this case, so we have to continue on. I would argue in this case that because of Timley, we have very clear evidence of legislative intent. The legislature has essentially adopted Timley because it's been the law for almost 20 years. We know that this legislature, first, has no problem amending statutes if it disagrees with this court's interpretation of those statutes. They've evidenced that time and time again in moving swiftly and quickly to change the statute to conform to their intended intent. Second, I would also note that during the course of this period of time, most recently, the criminal code underwent a major recodification, and the legislature didn't see fit to break out force or fear or to otherwise express a different intent from Timley. And I would argue that's an adoption of the ruling in Timley. And so as far as legislative intent goes, that should be the end of the analysis here.
We ignore Brown, is that what
No,
you're saying?
this is under Brown, under the first factor. If we have clear evidence.
Look at legislative intent.
Right, clear evidence. I'm sorry to interrupt.
No, that's all right.
Clear evidence of legislative intent is the end of the analysis, and I would submit we have that here.
It seems to me that if you're looking at, I think Brown talks about the material elements,
Yes.
and I sort of look at it as the gravamen of the culpability, that it's overcome. It's overcome by force or fear, and it's the destruction of free will as the gravamen, in my view, which makes just force or fear two ways in which you accomplish the overcoming of free will and consent.
I would look to the Peterson case that the court discussed in Brown, the Washington case, and in there they talk about whether or not the suggested alternative means, or what we're looking at as the alternative means, are separate and distinct acts by which the crime is accomplished. And here, the separate force and fear are separate and distinct acts. The case before this, there was some discussion about, do they overlap? And yes, without doubt they overlap in some factual scenarios, but they do not always overlap. And when they do not overlap, they are very different. And I would submit that the fear as a means of overcoming the victim's consent is designed to deal with a situation entirely different from forcible rape. It's designed to recognize that a victim does not have to resist to the point of physical injury, but still the state can still show non-consent in that scenario. It doesn't equate to consent just because the victim didn't bring about physical force. It's designed to cover those situations where there's a threat of, with the gun, do this or I will shoot you, but no actual physical violence occurs. But that does overcome their non-consent.
Do you agree with, if you were listening in the last, and I recognize that's not your argument here, but do you agree, I think, with Ms. Krebs, who said that the fear is related to force, must be related to force, the use of force, or the threatened use of force, physical force?
Not for purposes of taking a position in her case, obviously. I cannot do that. But I do think that they are related, but it doesn't eliminate the very separate nature of the two acts.
See, I don't see the separate nature. If the act is accomplished by slapping the victim, would you say that's by force?
Yes.
Well, I would say it's because the fear of being slapped again is why there's acquiescence in the act. And so the fact that force was applied carries with it the fear of further force, and so it's hard to uncouple those two things, which would explain why the legislature put them together and says you don't have to uncouple them. They're all part of the ways in which you can overcome.
I would answer that in two ways. They can overlap. That's an example of them overlapping. If the victim in that case testified, yes, I was afraid that he was going to slap me again, that's why I allowed this to occur, why I stopped resisting, whatever that testimony might be. Under the facts of our case, we don't have that, and there's no evidence of any fear. It was pure force. As it pertains to the two rapes, she testified in the bathroom for the third incident where there was an acquittal that she was scared during that event. And you can certainly be afraid during the act. I would posit that anybody would be afraid of a forcible rape, but they have to be overcome by. And if you have that testimony, by all means, but they overlap at that point.
Don't we have cases where we've determined that options within a means aren't necessarily overlapping or related? I'm thinking of, off the top of my head, felony murder, where we've said it's in the commission of or flight from. Those are totally different options within a means that don't necessarily overlap or unrelated, but we've said nonetheless they still qualify as options within a means. Why is that any different than this?
Well, then what is the discussion related to the Peterson case about then? If they're talking about the fact that you've got separate, distinct acts by which the crime, here non-consensual intercourse, is accomplished, establishes alternative means, then if also separate, distinct acts that are just options within a means can also, or are not indicative of alternative acts, then I'm not sure I see how that is even relevant. If it applies in both situations, I don't know how I can apply it.
Counsel, I see you're out of time. Would you like 30 seconds to wrap up?
I'll wait for rebuttal. Thank you.
Do we have any further questions of counsel before she sits down? Thank you.
Good morning. My name is Tamara Hicks. I'm an assistant Finney County attorney. I was not on the brief. My Supreme Court number, if you need it, is 15010. Our argument is that when you look at the construction of the statute, there are two separate ways that the legislature put forth that a rape can occur. One being the force or fear, that the victim was overcome by force or fear. Physical force, fear that there will be additional force used upon her. The second way is when they're unable to consent because of alcohol intoxication or drug intoxication, or a mental status where they are unable to have the mental capacity to consent. In our particular case, we are arguing that the first part of the statute, overcome by force or fear, is what is going on in our case. The victim and the defendant knew each other. They had been married previously, and she testified that he came home, said he wanted to have sex. She said no, she didn't want to have sex. He told her, shut up, don't make me get mad. She also testified that he had a bad temper. That was part of the reason for their marriage not lasting. She continued to tell him no. He admits to law enforcement and also during the trial that he did overcome her by force. He admits that she said no, that he held her down, he took her clothes off of her. So there's no question that force occurred. Our argument is that that is sufficient for the court to affirm the conviction of rape. We also will argue that there was testimony during the trial of fear. She stated her child was sleeping in the crib right next to the bed, that she was concerned that the child would wake up. The child did wake up at one point, climbed out of the crib, and got onto the bed. At that point, the defendant stopped raping her. She grabbed her clothes and ran to the bathroom and locked herself in there. He went to the bathroom, and additional sexual violence occurred to her in that bathroom after he had gotten in. She admits that she was crying, was upset, and was very afraid of the defendant and further violence from him. So we believe that there are two ways.
You have to have more than evidence of fear. It has to be the fear that has overcome.
Yes, I would agree with that. And I believe that the evidence in this case does show that that she was overcome by fear of what would happen to the child, fear of additional violence to her from her experience with the defendant in the past and his temperament and the way that their relationship had occurred prior to this event. We are arguing that the force or fear are options within the means, that the way the statute is constructed, with force or fear being separated from being unable to consent based on a mental deficiency or alcohol or drug in the system.
Could you clarify what you just said?
Yes. The way the statute is set out, the first subsection is overcome by force or fear.
And your position is that's an option, with force or fear is options within a means.
Right. And so that...
But the next subsections are alternative means. Is that what you just said?
Right. That if you charged force and unable to consent
Right.
because of...
Then you have to prove both.
Then you would have
Okay.
alternative means.
I thought that's what you said. Okay.
So based on that and the actual factual scenario in our case, we believe that there are two ways that the court can affirm the conviction for rape in this case, and we would ask that you do so. Are there additional questions?
Your argument that these are merely options within means, anything more you care to say to persuade us?
I believe that if they were not options within a means, they would be separated out in the statute, that they would not have lumped them together. I think it is very hard to distinguish between just fear or force. And I think that's why the statute was written the way it was, so it could include all of those scenarios where they do overlap.
So merely putting those each in their own separate subparagraphs would do what, as far as you're concerned?
I think it would give the situation where you might need to give an instruction of unanimity on those. So I think that when they combined it, that it was their intent for us to be able to not have the jury have to figure out specifically if it was force or a fear of force, or just this fear of a weapon or something of that nature.
Any further questions of counsel? Any further presentation?
No, thank you, Your Honor.
Thank you, counsel.
Just briefly addressing the issue of insufficiency of the evidence, if Timley does survive. If force and fear do not constitute alternative means of committing rape, because there was sufficient evidence here of force, Mr. Nunez does lose. I mean, he concedes, we concede, it's in the brief, that there was evidence of force here. The issue is on fear. But if this court reaffirms Timley, under the Timley supersufficiency standard, there must be sufficient evidence of each alternative means beyond a reasonable doubt. And in this case, the Court of Appeals found sufficient evidence of fear in two ways. First, that she was in fear during the rape, and second, it looked at the evidence where she testified she was scared during the incident in the bathroom that followed the rapes. Under the first finding, the panel was in error because there was no evidence, although there might have been some circumstantial evidence from which you could assume she was afraid, there was nothing that showed that her resistance was overcome by fear. The evidence was solidly that her resistance was overcome by force. And the fact that she might have been afraid during the event is not the same as showing that it overcame. As I note in State v. Borthwick, the court held that the statute requires the state to prove that the victim was overcome by force or fear to facilitate the sexual intercourse. And it was the force that facilitated it here. It was accomplished by force. Under the second finding, looking at the statement that she was scared during the event in the bathroom, the panel erred in that regard in using that evidence to find that there was fear during the two rapes. In Wright, this court held that the fear has to be contemporaneous eventually or at some point during the incident with the penetration, and that's during the rape. And so to look at being scared in a subsequent event, you can't use that to find that she was overcome with fear because it has to be contemporaneous during that previous event. So we would ask that this court reaffirm Timley and, applying Timley, hold that the evidence in this case was insufficient to prove each alternative means of committing rape, and therefore reverse Mr. Nunez's convictions.
Do we have any further questions of counsel? Thank you, counsel. Thank you both for your arguments this morning. Court will take this matter under advisement.